evidently contradictory letters issuing from the office of the Speaker of the Senate. Nonetheless, it appears that two speakers of the Parliament eventually resolved that the Finance Bill 2023 was a money bill. This determination is not binding on this court, which has jurisdiction to interrogate the legality of the position taken by the speakers. A money bill is distinct, being neither special or ordinary bill concerning counties. Thus, it is not subject to the procedure in Articles 110 to 120 of the Constitution, requiring concurrence of two speakers as a condition precedent and or involvement of the Senate, as was held in Faber's East African case. That said, in this instance, the position taken by the Speaker of the Senate in his letter dated 15th of June 2023 is not idle, as the Supreme Court, in the matter of the Speaker of the Senate and another, were discussing the role of the speakers of the respective House of the Parliament, observed as follows. I think it's necessary that I read part of this. This is what the Supreme Court said. Is it in doubt, that is quote, is it in doubt, in view of the formal provisions of the law, when and how the question for the consideration of the two speakers arises under Article 110 of the Constitution? We do not think so. No, Mr. Norgate submitted the requirement for a joint resolution of the question whether a money bill is one concerning counties is a mandatory one, and the legislative path is well laid out. It starts with the determination of the question by either speaker, depending on the origin of the bill. Such a determination is communicated to the other speaker with a view to obtaining concurrence. Failing a concurrence, the two speakers are to jointly resolve the question. Both sets of standing orders are crystal clear on this scenario, and both on this point, as we find, faithfully reflect the terms of the Constitution itself. It is clear, though some of the counsel appearing before us appear to overlook this, that the business of considering passing of any bill is not to be embarked upon and concluded before the two chambers, acting through their speakers, address and find an answer for a certain particular question. What is the nature of the bill in question? The two speakers, in answering that question, must settle three sub-questions before a bill that has been published goes through the motions of debate, passing and final assent by the President. The sub-questions are, is this a bill concerning county government? And if it is it a special or an ordinary bill? Is this a bill not concerning county government? That is number B. And C, is this a money bill? How do the two speakers proceed in answering those questions or sub-questions? They must consider the content of the bill. They must reflect upon the objectives of the bill. This is by the Constitution. It's not a unilateral exercise. And on this principle, it is obvious that the Speaker of the National Assembly, by abandoning all the engagement or consultation with the Speaker of the Senate and proceeding as he did in the matter before the court, and acting contrary to the Constitution and its fundamental principles regarding harmonious motion of state institutions. Neither speaker may, to the exclusion of the other, determine the nature of a bill, for that would inevitably result in usurpations of jurisdiction to the prejudice of the constitutional principle of harmonious interplay of state institutions. It is evident that the Senate, though entrusted with less expansive legislative role than the National Assembly, stands as a constitutional safeguard for the principle of devolved government. This purpose would be negated if the Senate were to not participate in the enactment of legislation pertaining to the devolved units of the counties. Our understanding of the foregoing pronouncement of the Supreme Court is that prior to either house taking up any bill, it is desirable, and we deliberately use the word desirable, it is desirable for the speakers to determine the nature of the bill and the path it should take. From the perspective of the Supreme Court, the two speakers ought to have concurred as to the nature of the bill prior to the introduction in the National Assembly. In any event, as already stated, the concurrence of the two speakers of Parliament cannot oust the jurisdiction of the court under Article 165 of the Constitution to interrogate such concurrence. We have a case here, the case of the Institute of Social Accountability, and another was the National Assembly, which stresses that fact. Having held that the Finance Act is a money bill, we are not persuaded that the failure by the Speaker of the National Assembly to seek concurrence from the Speaker of the Senate prior to the introduction of the Finance Bill vitiates the Resources Act. Concurrence of the two speakers is not a requirement under Article 114 of the Constitution.
Over to Justice Beverly for the next part.
Thank you, Judge. I will deal with two issues. That is issue number 2 and 3. Issue number 2 being Issue number 2 being whether the public participation conducted was sufficient. Issue number 3 being whether certain taxes cited in the petition and as enacted by the Finance Act are unconstitutional. Starting with the issue number 2, whether the public participation conducted was sufficient. The petitioners assailed the Finance Act